We are so excited about today's session on intellectual property, and we have the pleasure of Izzy Caulder, who's joining us today. She is an intellectual property lawyer. Izzy, please introduce yourself.
Happy to. Thank you. I'm Izzy Caulder. I'm a partner at Breskin and Parr here in Toronto. And I've been practicing for over 20 years now in a really interesting area. Intellectual property really covers a lot of interesting areas for our clients. I started my career as an engineering science student at U of T, and I did the program there, and then I graduated and did a master's degree, and then went back to law school because I didn't have enough school. And upon graduating from law school, I really missed the engineering. So I thought, okay, well, I'll go into what I hear is intellectual property law, which is technical but also law. So it's a really wonderful hybrid. And I have a lot of clients, a lot of startup clients that I work with, and I really try to empower them around intellectual property.
Super, that's great. Thank you so much. I can relate to the long road in university.
The long road.
um, okay, great. So for someone who's kind of just starting out, can you tell us a little bit about what is intellectual property?
Okay, yeah, happy to. So intellectual property is, it sounds very sort of abstract, but really it can be quite understood in a very concrete way. When you have a company, you're developing a product, for example, and you're thinking about putting it into the marketplace, you're thinking about first off a name for it. What will we call it? What will customers go to the drugstore and ask for? That will be your brand. That will be your trademark. So that's one type of intellectual property. Other things that break down into that category are how does it work? How does it function? What is the technology behind it? How does the data get moved around, or how does this lever work and clamp it onto your arm? Those kind of things can be protected by patents. So essentially, as sort of a functional aspect of the product. How it looks, how beautiful it is. Somebody wants to pick it up and put it on their arm. It's attractive. That's a design. So we call those design patents. So that's another kind of intellectual property. And then there's, copyright can be there in terms of the manuals that you're selling with the product. You're putting it in the box. There can be copyright on the instructions, that sort of thing. And then something that people sometimes forget about is trade secrets. So trade secrets are maybe your customer data, the people that have bought your product, or maybe some research you're doing in the field that you're keeping confidential. That can be, or some of the special combinations of chemicals you're putting together. You may not want to patent it, but you keep it as a trade secret. So that's just at a very high level, the different kinds of intellectual property that you might see in a box.
Super, that's great. Thank you so much. And so for a medical student, what are some considerations about intellectual property in the context of commercialization, whether it's a research project or otherwise?
Right. So if you're in that context and you're developing some intellectual property, and there are these different types of IP, but at the end of the day, anything that really is proprietary, anything that you have come up with, you've created. I mean, the first thing to think about is, what equipment are you using? What are your roles? Do you have multiple roles? Are you a graduate student at a university with certain obligations? Are you starting a new company of which you be the sole proprietor or a shareholder in? So there are all these levels of, who owns what. And that is something that I think a lot of people who do research and then think, well, there might be something commercial here, really come across very quickly, who owns it and what are the rights that I have to navigate.
Interesting. Okay, super. So we talked about the different kinds of intellectual property.
Hmm.
How do you know what path to pursue to protect your intellectual property?
Right, and that does take a bit of reflection. So I think one of the things we always say is it's really important to be timely with your reflection. So when you have something that you've created, it is worth taking a step back. And there's 100 things to do, but what a very important thing to do is to take a step back and say, well, you know, what are we creating and where will the value be down the road? And so before time goes by and you lose rights, it's important to, for example, file a patent application. Just by filing a patent application gets you in a queue for patent examination, and allows you to, get ahead of maybe another team who might want to file their patents. So you want to think about, what's important to do now. We shouldn't wait. Also, branding. If you're thinking of some names, it's good to make sure that you can use the name that you've come up with. It's good to do some searching, see if anybody else has the URL. Maybe they have the website. Are there other names that are close? So it's good to sort of take a moment, talk with an IP lawyer, ideally, get some idea of, what have you created? What IP could there be? And let's talk about what your plan is. Is it to license it? Is it to make it? All these things will affect the kinds of IP strategy that you would take.
Hmm. What a big topic.
It's a big
It's a
topic.
lot to learn about. Um, so I guess one of the other questions I had was oftentimes medical students or physicians or scientists are working in the context of an institution.
Yes.
For example, like the University of Toronto or a hospital. How do you
Mhm.
navigate the intellectual property associated with discoveries or things that you're commercializing in this setting?
Right. And that's a big, big question too. So, as you know, all universities and educational institutions have transfer offices. So they have people that their role is to basically look at, how best to administer the research and the findings and all the IP that's coming out of the research activities at the university. And it's very interesting because every university is different. Some of them say, look, we are first owner of anything created. Others say, it's yours. Other institutions will say it's joint. But whatever you have to do, I always say this to people coming with that question, really important to have a conversation with the transfer office and somebody in there describe, what you're doing, what your setting is, understand the policy of the university, and then you can navigate from there. But it is a very complex topic. There's a wonderful organization called Autumn where all the tech transfer folks get together and talk about how best to promote research and innovation, how to understand licensing, how to understand all the factors that go into that sort of activity. And, I was just looking at the conference coming up. They've got a session on clean tech, for example, which is a real area of passion for me. And the question is, how do we accelerate research getting out there for solutions for climate change? And how can we facilitate that? So I think it's a very important role and a very important thing that people need to have conversations about.
Super, that's
Mm-hmm.
great. What is your advice for medical students or trainees that are looking to learn more about this topic?
So there's so much information out there.
Definitely.
And I work with a lot of startups. And so I've actually come up with a series of IP maps, which I will provide to you for handouts
Super.
as well. And so essentially, there are so many resources out there and there's so many ways of learning about it. I understand as medical professionals and students, I mean, time is so short, right? You're deep diving into your studies and all the requirements around licensing and everything that you have to do. There's so little time. So professionals like myself, we volunteer at different accelerators. We volunteer in the community, and we do offer assistance and to sort of say, well, what do you have? What is your situation? And let's try to learn by applying it to your situation. What are the things that you're looking for? You're looking for to start a company, maybe to have some investment, maybe you're looking to license. We can start with what you're looking for and describe what IP solutions are available. But there is a lot of information online. Again, IP maps that I've created try to really simplify the stages
Mhm.
of the different things that you would need to do to really demystify it, because it is just there are processes for these different things.
That's right. Yeah,
Mm-hmm.
definitely. Many courses, and I think they're IP courses in and of themselves.
They're IP courses
Yes.
in and of themselves, and I'll tell you, actually, we as a firm, we just had 6 people who are writing the patent exams all pass, which
Wow,
is it's
congratulations.
the first time it's ever happened. About 40 people in the country passed the exams this year, and we had 6 of them, which is fantastic. But you're right, it is an area of study, and it is quite challenging. So we try to demystify it, make it as simple as possible, as practical as possible. And there are a lot of resources. For example, Mars has a great website with a lot of different documents that could be useful, like a non-disclosure agreement.
Yes.
They have share agreements. They have all sorts of interesting documents that could be useful. So,
Super. That's
yeah.
great. I think that there's a lot of kind of questions or concerns regarding funding for intellectual property
Yes.
and filing patents. How do you think that students or trainees can go about learning more about those opportunities to
Mhm.
support filing patents and also kind of navigate the granting system surrounding that?
Exactly. No, you're right. I mean, the thing about IP is that the costs do vary. And so in one of my maps, I talk about patents. I always say they're the kind of the Cadillac of IP because they are very expensive. But luckily, there is funding available. Government programs, unprecedented government programs have just been released. And I actually have a map that sets out 3 of the main ones. So the NRC, IRAP has an IP Assist program, which is fantastic, different stages that can really help fund some of this IP strategy that we've been talking about. It is quite IP strategy oriented. Then there's Elevate IP, which provides financial support for filing applications, doing searches, filing trademark applications, things like that. And then there's IPON as well, which is an Ontario-based program. So all these funding organizations and programs have started, and a lot of my clients are using them. A lot of people are using them, and they're fantastic. But there are some things to navigate. So how do you get involved? Some of them have very simple: go onto the website, look up the program, learn about it, sign up. Essentially, start the process very simply. So it is worth investigating. But you can get quite a bit of support for the IP work that you need to do. And so it's good to know that they're there. We had somebody at my firm, we were educating ourselves about it a couple months ago. Somebody raised their hand and said, well, how long do these programs normally last? And the answer is, this is unprecedented. This has never happened before. So it's a real opportunity to think about what you might be creating and then going to get a bit of support for that, for the protection of that.
Super, that's great. It's really nice to know that these resources are out there.
Exactly, exactly. And again, there are a lot of IP professionals that would be happy to sort of help you kind of go through those programs. The accelerators themselves are administering these programs, and so they also are a good resource to go and sort of, ask those questions.
Great. If you could maybe comment on, what do you think are some common pitfalls that trainees or individuals in the life science or health science encounter when conceptualizing intellectual property?
Mm-hmm. That's a very good question. And actually, during COVID, a number of my colleagues and I, we were putting together sort of, what to think about during the pandemic, because a lot of things are happening and deadlines are being missed, and really trying to just make sure that people don't fall into these pitfalls. The big one is time going by, there being, a public disclosure of your invention without an NDA. So maybe you take it to, life science professionals are always going to conferences and putting things on posters and disclosing. That is one of the big traps. If you disclose an invention in an enabling way, you may not be able to get patent protection for it later. Mm-hmm. So it's really important to try and get as early a filing date on subject matter as possible. And I tell my colleagues at work, our job is to get our clients as early a filing date as possible for their subject matter. And then, the prior art that's applicable stops at that point, and you're first in the queue in terms of getting a patent.
So file quickly.
File quickly, as soon as you're ready, as soon as the invention is sort of ready for patenting.
And exactly. What is prior art?
Yes, that's a good question. Of course, it's something that we just have in our heads all the time. So prior art is really anything. It can be a journal article. It can be something on a poster that you've seen at a symposium. It can be, IEEE magazine article. It can be your thesis if it's publicly available. It can be research, a research paper that you put in. Again, all of these things have certain confidentiality around them, or maybe during the review process, there tends to be confidentiality. But once it's publicly accessible, then it counts as what we say is prior art. That means if you file a patent application, the examiner, when they receive the application, will look at the filing date and then go and do a sort of patentability search. And they'll find articles, they'll find whatever's on the web, and they will use it to determine whether what you have is new and different, whether it's patentable. And during the process of prosecution, if somebody, a third party, wants to challenge your application or your patent, they can actually say, well, actually, this was on your poster at the symposium, and this was, before your filing date. So you've got public disclosure. Then we're into other things like grace periods and things like that. But we basically say, you want to get as early a filing date as you can to limit the amount of prior art that you're facing as a potential patentee.
That's great. Okay, so another question and consideration that we have is, so if someone has something, for example, like a software or a device or a drug, that they're thinking about the patent or intellectual property route, how do you, or what are the considerations that go into either pursuing a patent or pursuing kind of trade secrets, and what are the considerations in that regard?
That's a terrific question. And actually, this is something that we work with clients quite a bit on. And in fact, a client a number of years ago said, look, we do a lot of patenting with you, but we don't have an unlimited budget. We have to make choices. We have to say, okay, these features or these aspects or these products, we're going to come at from a patent point of view, but there's some other IP there that we will keep as trade secrets. We see that even in a product itself, one single product, parts of it you might keep as a trade secret and parts would be strategically best to patent.
Interesting.
And this is all based on some considerations. That same client said to us, we need a process for this. We're going to sit down as a company and go through these inventions. We need a process. So we came up with a nice flow chart, and I have a map that sets out the different considerations, and it kind of takes you through the thinking. But at the very base of it, it's how easy, how practical, or how realistic is it to get meaningful patent protection on one hand, and how easy is it to keep it secret on the other. So
Mm-hmm.
those are really the two main considerations, and there's some subtleties in there, but that's the basic way to think about it. So you look at a product and say, well, there's something here that's encrypted that's very unlikely to be discovered. Or if, for example, you're just spitting out a number, you've done some kind of, you're using AI to kind of figure out something, maybe something medical, and then you pop out a diagnosis. If you maintain all the control over the server, people will just get the result, they'll get the diagnosis. And so in that case, a trade secret, keeping this part trade secret makes sense because it's easy to keep that secret. If you have a medical device that's easy to reverse engineer, if somebody just gives it a bash and they can open it up and see how it works and make another one, then that is not the best protection.
Mm-hmm.
You would want to try and get some meaningful patent protection for the gizmos inside. So,
Interesting. Okay. So, and I guess the trade secret is sort of like the black box, as we talk about, or
the
the
black
secret
box.
sauce.
Exactly. And
Yeah.
as if it can be a black box, then it's much more amenable to trade secret protection.
Mm-hmm. That's
Exactly.
right.
The secret sauce.
That's right.
Yeah.
So it seems like there are sort of different ways that you can go about it. There's no right answer, and in some cases, you can do a bit of both.
Exactly. There's no right answer, but in some cases you can do a bit of both. And for example, a client of mine will have a manufacturing process that's all done sort of internally to the factory. That kind of thing is perfect for trade secret protection. We're not going to be, shipping that out or opening the doors to show people how that works. You can keep that under lock and key. One thing I would mention about trade secrets is, with patents, we know that you have to pay fees and you have to file documents and you have to wrangle with the patent office. On the trade secret side, you have to take reasonable measures to keep things secret.
Mm-hmm.
So there's no filing that needs to be done. There's no statute that you need to comply with in terms of like you do on the patent side. But there's case law and there are some statutes depending on jurisdiction on how you need to maintain things trade secret, maintain things secret. So those sorts of things. It tends to be mostly in agreements. So when it comes down to it, it really is what is the language you're using in your employment agreements, agreements with third parties,
Mm-hmm.
how are you treating your information?
So the last question I have for you is, what is one piece of advice that you would give to medical students or medical trainees in this area? Really, what's one piece of advice or a take-home message, really, about intellectual property?
I think not to be afraid of it, to really just go into it. I know there's limited bandwidth and limited time to explore things that are outside your core area, but it is really good to know. I mean, I have so many clients where their intellectual property ends up being their most valuable asset. They are maybe selling their company or they're licensing it or they're, monetizing in various ways. And because, the secret of how to do something, how to make something work, especially in the life sciences area, like you found a combination that's really powerful, to protect that with IP can be so important to the worth of the business later or the viability of the product or the attractiveness to investors. So I think the big message is not to be afraid of it. Come and talk to people who can help demystify it for you, and then understand. Okay, I've created something new and different here. Let's not tell people about it. That's actually probably one of the most important things. Try to keep it under your hat. Go get a non-disclosure agreement. They can be very simple. Have those executed by people who you are disclosing it to, and then go and consult an IP professional to really help you understand. Do you have something interesting here? Let's get something filed, and it can be done. I know generally speaking they're expensive, but they can be done on a cost-effective basis. You can file what's called a U.S. provisional patent application, which has lower fees. There are government funding programs out there as well, and then there are also, just between us, pro bono policies. Like, for example, my firm just put into place a pro bono policy to assist certain owners from certain communities and also clean tech inventions. So there are all sorts of, where there's a will, there's a way.
Oh, that's amazing. That's very, very exciting to hear.
Mm-hmm.
Well, thank you very much for taking the time to join us and for talking
Absolutely.
about this very important and interesting subject.
Mm-hmm.
I think we learned that there are so many aspects of intellectual property and types of ways to protect your intellectual property.
Mm-hmm.
Um, And, for students that are looking to learn more, I think it's really reassuring to know that there are many resources out there, as well as opportunities to speak with professionals like yourselves. So we're very fortunate to have a real IP lawyer with a lot of experience in this area to educate us. So thank you very much for joining us.
Thank you for asking me to come on here. It was really fun.
Thank you.
Thank you.